Good morning, and thank you for joining us today. This is another in a series of webinars that we have hosted on Camp Lejeune. And in this webinar, we are briefly going to go over the basics of the Act for any of the newcomers to this litigation. But the majority of our presentation will focus on new material concerning the administrative claims process. So for you, those of you who are experienced in this litigation, just bear with me as we go over some older material. So first, here's our team at Beasley Allen working on this litigation. Julia Merritt and LaMacchia are leading up this litigation. I'm working on it as well. And then we have a whole other team of attorneys who are playing crucial roles in us moving this litigation forward. So this is more of just the recap of the bill itself. Nothing too new to go over, but for those of you who may not have been involved as much as others, there are some very unique aspects of this bill that deserves some close attention. So first of all, the Camp Lejeune Justice Act is part of a larger bill honoring our PACT Act. Camp Lejeune Act was signed into law on August 10th, 2022. This is going to be a very important date, so keep that in mind. Because this is a unique statute, the Act has some very important aspects that makes it a little bit different than most civil litigation. First of all, who is covered? Anyone exposed to water on Camp Lejeune for 30 days, it doesn't have to be consecutive, is eligible. And so that includes servicemen, servicemen's families that lived on base, a child exposed to water in utero, or civilian contractors. The exclusive jurisdiction is in the Eastern District of North Carolina. And this is not a multi-district litigation. And so the JPML consolidation rules are not at play. The venue was created by the statute. The Camp Lejeune Justice Act imposes its own statute of limitations and statute of repose that supersedes North Carolina's standard statute of limitation and statute of repose. This extends to a wrongful death case as well. A wrongful death case for this action can be brought even if the decedent passed away decades ago. The statute allows for a claim to be filed within 2 years of August 10th, 2022, and then an additional 6 months to file a civil claim, whichever is later. So you have to file an administrative claim by August 10th, 2024, and then file a civil claim 6 months after that. That's why that date is so important. Now, a prerequisite to filing a civil action under this federal statute is that an administrative claim must be filed first. We will go into more detail about the administrative claim process in a bit, but generally speaking, it's important to know that the administrative claim that is filed is not under the Federal Tort Claims Act. The administrative claim for purposes of this act serves merely as notice to the government. The act also limits the government's defenses. I've mentioned the adjusted statute of limitation and statute of repose, but also the act removes immunity and the Ferris Doctrine from the government's arsenal. I believe most people are well familiar with immunity, but the Ferris Doctrine is a defense that prevents the members of the armed forces who are injured while on active duty from successfully suing the federal government under the Federal Tort Claims Act. And since the Camp Lejeune Justice Act does not travel under the Federal Tort Claims Act, that's why that doctrine is inapplicable. Now, the act does not allow recovery of punitive damages, but only compensatory damages. So that is why it is so important and crucial to know your clients and to know their stories. And even though an administrative claim is required prior to filing a civil suit, under this act, the Camp Lejeune Act is wholly separate from the Federal Tort Claims Act, and I just can't say that enough. And attorneys should use caution submitting their administrative claim to ensure that they do not file under the Federal Tort Claims Act. Another unique aspect of this litigation is the burden of proof. In traditional civil litigation, the burden of proof is preponderance of the evidence, and that requires greater than 50%. For this litigation, the term is called equipoise, and that burden is as likely as not. And so that allows for proof that is.
Thank you so much. Thank you. Bye. Bye-bye.
that allows for proof that is at least 50%. The standard is considered equipoise, and it was a term that you'll hear a lot in this litigation. So next, we're going to talk about a few litigation updates before we jump into the new material. And so first, I wanted to talk about legacy cases. When the act was passed, a certain subset of cases were filed in the Eastern District of North Carolina, about 37 cases. In these cases, the plaintiffs had filed an administrative claim, and it was denied, but the claim was filed under the Federal Tort Claims Act framework prior to the passage of the Camp Lejeune Justice Act and prior to the adoption of the unique Camp Lejeune Justice Administrative Form. Because of these facts, the Eastern District judges dismissed all of these cases based on a failure to exhaust administrative procedures. Essentially, since the case was not denied under the adjusted Camp Lejeune framework, the judge stated that the plaintiffs must first comply with the new administrative process created specifically for the Camp Lejeune Justice Act claims before moving forward with litigation. Oh, sorry about that. So there have been cases that have been properly filed at this point. The bill was passed on August 10th, 2022, and that means that the earliest a case could be filed properly was February 10th, 2023, since it is 6 months from that August passage date. Now, as of this morning, approximately just under 100 cases have been filed in the Eastern District of North Carolina since February 10th, 2023. And another thing about the Eastern District, they have some specific rules concerning how to file cases. So for those of you who are gearing up to file cases in the courts, be aware that the Eastern District of North Carolina has specific filing rules in place for Camp Lejeune cases. This information is on their website. It's actually across a big red banner. But what you need to know is that the residency of the lead plaintiff will dictate what division you file the case in. If the plaintiff does not reside in North Carolina, the case should be filed in the Southern Division. For a client who resides in North Carolina, Local Rule 40.1 lists which counties fall into the different divisions. Now, as a matter of housekeeping, when you're filing these claims with the Eastern District of North Carolina, the cause of action should be listed as 804, and that's an internal reference to Camp Lejeune Justice Act. The nature of the suit should be listed as 360, which is PI other. And now that we talked about the Eastern District, the Department of the Navy, which we'll talk about a little bit later on, also has some requests if you're looking towards litigation rather than resolution through the administrative claims process. Leslie and Julia will talk a little bit more about this, but in the context of litigation, if a firm is intending to file a case after a 6-month period, rather than waiting to move forward with either the administrative claims process, which will include perfection or substantiation, the Department of Navy is requesting that that firm contact them with a list of cases that they intend to file, and the Department of Navy will then begin the process of getting those cases transferred over to the Department of Justice. Now, Julia will touch a little bit more on the different roles that the Department of the Navy will play versus the roles that the Department of Justice will play. And so more of the new material that we're going to be covering is the administrative claim and news from the JAG. The Department of Navy has released some preliminary information about the administrative claims process, and it's the first concrete update that we have received. And so Julia will be talking about this in depth. Next, we're going to talk about the mechanics of the administrative claims itself. In addition to releasing information about the process generally, the Department of Navy has also released specific information about the mechanics of the administrative claim process and what must be done to capture that elusive, perfected claim. So Leslie will share more on that information as well. And with that, I'm going to pass this on to Julia so we can start covering some new material. Once again, thank you all so much for attending.
Hi, I'm Julia Merritt. Thank you so much for coming. I know you're all very busy and you have a lot going on, and so we appreciate you tuning into this, and I hope that we'll give you some substantive updates to help you, process your administrative claims and litigate these cases. I'd also like to welcome you to file any questions. There's a button at the bottom called Q&A. So I would love to answer questions, and don't let us just be up here with be talking heads. Let this be an interactive seminar for you. And finally, at the end of the webinar, we will tell you how to get CLE credit and all that jazz. So we have a lot of good information to share with you, I hope. So first of all, what you see on the case on the screen right now is an internal document that we created for our clients. And the purpose of this is to just explain what this process is all about. It is confusing. Litigation in and of itself is confusing. Then add a statutory prerequisite and it's extraordinarily confusing. So we have created this document to kind of walk through with our clients if they have questions about the process. As we all know, it is a two-step process. There is the administrative claims process with the Department of the Navy that is being worked out with through JAG. And then once the case is litigated, it is being transferred over to the Department of Justice. So I'd like to just kind of go through this process in detail with each of you and dig in a little bit. So next slide, please. This is the same document. It's just zoomed in so we can see it a little bit better. And I just want to talk about what happens from the time that a client calls in initially to start your case. Obviously, we need to get their intake information. We need to get their legal name, their birthday, the dates that they were on base, and their diagnosis. Now, we are requiring a confirmation of diagnosis from a doctor's office or a hospital. We're not just taking the client's word for it. And I think that's really important to do. We're also looking at the DD-214 to look for times on base and confirm that if possible. If it's not on the DD-214, we are requesting full military records, but we are taking the client's word for it right now until we get them the records from the military. But what we are requiring from our documents is a lot of signatures. So I want to tell you all of the forms that we're asking our clients to fill out and sign. Of course, we need a fee contract, for every case. We are requesting medical record releases, high tech and otherwise. We're getting military authorizations. We are requesting that our clients sign a claims form. Now, the way that we are submitting our claims is via batch filing through the CSV process. So we're not actually submitting those claim forms to the Department of the Navy, but we are requiring our client to sign it, and we're keeping a pristine copy in a file. And I'll talk to you more about the reason why. Finally, we're requiring our client to sign a document that we created, and it's called an authority to file an administrative claim and or open an estate. Again, we just need our client to give us authority to file on their behalf, and we need to make sure that it's in writing and that we can produce that to the Department of the Navy on request. So you heard me say an authority to file an administrative claim or open an estate. So I'd like to talk a bit about the estate process. So we are requiring our clients to open an estate prior to filing an administrative claim. I am not telling you that that is legally required. I don't know. Okay, it's up in the air. Some folks are filing without an administrative claim opened, but I personally think, and we at Beasley Allen think, it is the best practice to get an estate opened for a lot of different reasons. The first of which is the actual claim form that you have to submit to JAG under Section 11 reads as follows. I'm just going to read it to you. This is a quote. An authorized agent must provide evidence establishing express authority to act for claimant, showing legal title and capacity of person signing with evidence of authority to present a claim. Please attach document with your claim form. Now, on the other end, we're hearing from the Department of Navy, do not submit any other documents other than the claim form. So we are not actually submitting another document, but we have it in our file. So we need to be able to have an estate opened and have authority to file and be ready to present that to the Department of the Navy on request. And I feel pretty comfortable and confident that that's the best way to go. There are other reasons why we want to open an estate before filing the administrative claim. First of all, if we get a settlement, we need some sort of legal authority to be able to hand the check to our client, and they need to be able to deposit it in some sort of an account that's legal. Secondly, if we are going to file a lawsuit in the Eastern District of North Carolina, obviously we have to have the party with the proper standing, and we need to have an estate opened for that reason. Furthermore, we are finding that about a quarter of our claimants are deceased. So as we all know, there is a lot of volume in Camp Lejeune litigation, and we don't want to be scrambling on the back end trying to figure out proper parties and estates and all that stuff. It's just really a safer practice to get the estate opened now. And finally, because we've all heard the ads, we've all heard, how many people were on Camp Lejeune between the requisite years of 1953 to 1987, over 1 million people. Well, think about all of the different types of families that we have out there. We have half brothers, we have divorces, we have step siblings. So there are going to be a lot of different people who perhaps rightfully believe that they are the claimant with the proper standing to bring an administrative claim on behalf of a deceased parent. They may not be the proper party. So that's why we're requiring an estate. And it also weeds out these potentially fraudulent claimants. We want to make sure that we can, look our client in the eye and know that this is the proper party. And if we ask them to open an estate and they say, there might be something there. So I encourage you to go through the process for decedents and make sure you have proper standing. So why am I so worried about this? Why are we going through all of these processes to get all these client signatures? You can go to the next slide, Matt. One of the reasons is there any way you can zoom into that? Thank you, that's better. One of the reasons is when filing batch claims under the Camp Lejeune Justice Act, we are, there are several ways that you can file. The batch claim is the way that we at Beasley Allen have determined is, the best for our clients. And that's how we have all of the backup information on our system, on our files. But we submit, it looks like an Excel spreadsheet, basically, with a bunch of different columns. It says the name and the address and date of birth. And you check the boxes of the presumptive injuries, you add additional injuries, and it doesn't have a client signature with it. So what I am doing as their attorney is I have to submit, according to the Department of Navy, this letter as a cover letter. And the language on here is pretty important. Look at paragraph 2. It says, I certify as the attorney representing the claimants below that all supporting original forms and authorizations to file claims with original signatures have been verified and are accounted for and can be provided to the Department of the Navy upon demand. That's a pretty big burden for an attorney. And so that's why the vetting process and getting your documents and signatures in order is so important. And another reason, if you need another reason, is if you could go to the next slide, Matt, is this. The potential penalties. So there are 2 potential penalties, and one is a civil penalty, which is for the claimant. And as you can see, this is actually written on the claim form, and it says the claimant shall forfeit and pay to the United States a sum of $2,000 plus double the amount of damages sustained by the United States if you submit a fraudulent claim. So we need our clients to understand that. This is important. is, so we need to be completely accurate. These documents are under oath. It's the same thing as filing an interrogatory response. It is under oath. They are verified. And then there's this penalty for attorneys. So, dot your I's and cross your T's and make sure that you're doing this right, because none of us want to go to jail. So I don't want to go to jail. And it says fine of not more than $10,000 or imprisonment for not more than 5 years or both. So that's just another reason why we just need to be so careful. Next slide. All right, so here we are again looking at this case progression. And so we've talked about the intake information and the verification. That's where we are now. So now we're in this third box, submission. That is when we actually send it to the Department of Navy with as I said, I'm doing the CSV and then the cover letter. And then the next step is to receive a letter of perfection from the Department of Navy. That comes, via email. If you're submitting your claims by email, you get this letter. It's from Jennifer Langley, who is one of the attorneys in the torts department. And she gives you the receipt of claim. It tells you the date that it came in, and it assigns a claim number. And that is the claim number that you need to reference in the future when dealing with the Department of Navy. So the date on that form so far has been the same date that we have actually submitted claims. So, if you pushed send on August 31st, then, we got a letter in February saying, yes, we received your claims dated August 31st, and here's your claim number. That claim date that we submitted the claim begins the process of the 6-month period. So start counting on the date that you hit send. That's your 6-month period. All right, so what happens after you get this perfection letter? There are 4 potentials. The first is if the Navy accepts the claim and the client receives a settlement offer and the client accepts. That is what I would call a unicorn. That would not happen very often. It hasn't happened to us quite yet, but it is a possibility. The second option is you get a settlement offer and your client rejects it. Okay. The third option is the denial of the claim. And of course, within this is the substantiation process that Leslie is going to dig really deep into. So I'm not talking about substantiation, but Leslie will, about what you need to do if the Navy says, yes, we accept your claim, but we need more information. So as I said, the third is if they deny in writing. No, you don't have the proper claim for whatever reason. You weren't there for 30 days, not an applicable illness, whatever, you haven't substantiated your claim. Or the fourth is no response. So let's say that you submitted your claim on August 31st, 2022, and you receive a letter of perfection, and that's the end of it. You don't hear anything else after that 6-month period after August 31, 2022. After 6 months, your claim is deemed denied. And that is when you need to make a decision. What are you going to do next? You have a couple of choices. You can wait, and you can wait for a letter of substantiation from the Department of the Navy, and you can try to negotiate with the Navy on settlement. Or you have the opportunity to file your claim, file a lawsuit in the Eastern District of North Carolina. So Matt, I think there's another slide here. Okay, yeah, here we are to step 2. So step 2 is filing. And obviously we are all experienced litigators on this call. We know how to, draft a complaint and go through the process. But as I said before, this is really for the benefit of our client because it's such a complex 2-step process. So, however, once if you choose to go the litigation route, your case is no longer pending under the administrative claim. They literally take it and transfer it to the Department of Justice. So no more interactions with the JAG, no more potential settlement with JAG, and it goes to a completely different department, the Department of Justice. And then that's who is the defendant in this case. So, it's a business decision, it's a litigation decision, it's a decision that you and your clients need to make together and determine how you're going to handle this. So, obviously then you go through the typical litigation process that we all know and love. All right, Matt, next slide, please. So we've gotten some updates from the JAG, Jennifer in particular. We have heard that they, between August and October of 2022, that they're perfecting claims for those dates. During those 3 months, 10,000 claims were submitted. And to give you an idea of the volume that they're receiving, their yearly average is 1,500 to 2,000. So in 3 months, they received 4 to 5 times what they normally receive in a year. So they are very, very busy. After the next batch is after October 2022, they've received more than 10,000. So again, it's exponentially more than they are used to processing. And they did say in a letter that claims that are submitted by CSV, which is that special Excel spreadsheet that I told you about, are given priority. And I think it's just because of ease of reference, it's all in one place. So Leslie now is going to talk to us about digging into this perfection process, the substantiation process, and the different terminology that the JAG has been using.
Hi, everyone. Thanks, Julia. My name is Leslie LaMacchia, and I am, Matt, you can go to the next slide. I'm going to talk about what happens next after you actually filed the administrative claim. There are 3 key terms that I want you to be aware of after you've actually filed the claim. 1, perfection. 2, substantiation. And per the Department of the Navy, what actual presumptive conditions means. Perfection is the process of reviewing a submission by the Department of the Navy and determining if it constitutes a properly presented claim. Substantiation is you will receive a letter request from the Department of the Navy for documentation, additional documentation to support your administrative claim. Presumptive conditions, as we all know, are the injuries listed in box 10 on the Camp Lejeune form that you submit. Please note that these injuries are only considered by the Department of Veterans Affairs as presumptive. The term presumptive conditions per the Department of Navy is only for ease of reference and does not indicate any adjudicative decision or merit. Now I'm going to talk specifically about perfection. Matt, you can go to the next slide. So as Julia mentioned, perfection letters have started to go out for those claims that were submitted between August and October of 2022, with those being submitted by CSV as priority. They're being given priority. And so we've been told that unperfected claims, if it's deemed unperfected, they will have gone through around maybe 3 times of review before you receive a letter of unperfection. But I'm going to talk about, perfection is the term of art used by the Department of Navy, as I said, to review a submission and determine if it properly constitutes a properly presented claim. You will receive a perfection letter, and the Department of Navy will provide you with a case number, as Julia said. If the Department of Navy determines that your claim is not perfected, they will outline all of the issues needed to be resolved in order to perfect the claim. So perfected versus unperfected. Common reasons for unperfected claims. I'm going to go through each one of them. I'm going to start with legal names. You need to file your claim with the actual legal name of the claimant. No nicknames, no initials, no, abbreviations, anything like that. If the agent is an executor, for example, you also need to make sure that the claimant's name is in there and that the letters, the perfection letters, will be sent as in the estate of the claimant's name. The basis of the, for standing to file a claim, this refers to deceased persons, trustees, family members of a claimant. For personal injury claims, the agent has to be duly authorized. If the agent's not duly authorized, the letter you receive from the Navy, the Department of the Navy, will be unperfected. For wrongful death claims, the estate must be represented by a properly appointed legal representative. The letter, I'm going to show you an example of a letter shortly, but I want to also explain to you, for purposes of determining perfection, the Department of the Navy has been construing the word miscarriage to mean loss of a non-viable fetus and stillborn to mean the death of a viable fetus. Some certain is another common reason for an unperfected claim. Per Black's law, it is a settled or fixed amount that is specified in as sum payable. So there should be no question on the claim form as to what you're seeking in damages. The basis of the claim, this is your job as attorneys to give a good faith description of details, facts, and circumstances surrounding the incident that allows the Department of Navy to investigate the claim. If you choose other as the basis of the claim and the cause of action is unclear, the claim will be considered imperfect. If you are alleging a loss of consortium claim, you need to understand the nature of the derivative claim and provide the Department of Navy enough information to ascertain the associated claim. If you already have a claim number for that associated claim, the Department of the Navy will ultimately link the two together. Lack of authorization as a reason why the claim will be considered imperfect, that pertains to paper claims only. So you need to attach all appropriate authorizations with the claim if you're submitting it in paper format. Here's an example. If the executor signs the claim form, but you fail to send the Department of Navy estate qualification documents, it will be considered unperfected. However, if you are sending claim forms by a CSV, the Department of Navy ultimately on a rolling basis is auditing all the necessary forms and authorizations as they go through them. Another reason why a claim might be unperfected is if there's more than one claim or claimant on a form. This means if you are alleging personal injury for a claimant and also loss of consortium for a claimant's spouse, it cannot be on the same claim form. That will be counted as an unperfected claim. Incorrect agency. The Department of the Navy is the Department of the Navy. The Marine Corps is a part of the Department of the Navy, not the VA or other military branches. So make sure that your agency name on the claim form is correct. All right, let's take a look at a perfection letter, Matt. This is an example of a perfection letter that Beasley Allen received for a claim that was submitted in August of 2022. As you can see, it does say that this claimant, the submission was reviewed and it was determined that it does constitute a properly presented claim. Awesome. So we're good to go on this one. And then I'm going to hit on substantiation next. But as you can see, in this letter I read to you before, you can see that one of the paragraphs does talk about, for purposes of determining perfection, how the Department of the Navy is construing miscarriage and stillborns. Okay, so let's talk about substantiation. What's next? So since claims are still being reviewed on a rolling basis, I said before, these letter requests are being sent by the Department of the Navy to attorneys asking to provide evidence to substantiate the claim, including medical records, bills, service records, and such. The Department of the Navy is also asking claimants to fill out another questionnaire. I will show you that in a minute. Matt, if you could go back, if you don't mind. So on the left of the screen is the substantiation letter, and it ends up being one of this sample letter here is a 3-page letter. And they're also asking you and incorporating a questionnaire. They're asking the claimants to fill out another questionnaire that mimics basically the claim form. So in my opinion, when I've seen this, I believe that the substantiation letter that you'll receive is the government version of a mass tort plaintiff fact sheet, also combined with like deficiency letters. Now you can click on the substantiation letter, Matt, thanks. And y'all, you are gonna get, at the end, I think you get the PDFs of this presentation, but not these sample letters. So if you want a copy of the perfection letter, the substantiation letter, or the questionnaire, let us know. We can email those over to you. So this is a 3-page substantiation letter. As you can see, they ask for everything under the sun here. You can keep scrolling so they can see what they're asking for. They want copies of military records. They want you to identify the location of the home. They're asking for the questionnaire, as you can see. Keep going, Matt, scroll down. So here, this letter is 11 requests: medical records, medical opinions, itemized bills, civilian medical records, copy of inpatient medical records. And then at the very end, here's the kicker: failure to provide all the requested information may result in denial of the claim. So that's the kicker. So again, like I say, it's my belief that this is basically the government version of the fact sheet combined with deficiency letters, and you providing them with all of your discovery in the initial stages of this case. And the questionnaire, Matt, you can click on that. You can see here, it basically mimics all of the information that you've previously provided to them. So don't get me wrong. They've already said, if you receive the substantiation letter, your claim has already been perfected. So they have a copy of the claim form. Now they want you to substantiate it. And then on top of that, fill out an additional questionnaire that basically mimics the claim form, the same information. So perfection, substantiation equals adjudication by the Department of the Navy, and hence it might be next be ripe for negotiation. Now, what happens next if you need to withdraw or amend any of the claim forms that you've previously submitted? Well, if I need to make a change, this is important. By way of which you have actually submitted the claim is the same way, the same manner you need to either withdraw or amend it. For example, if you submitted, here's one example here. If you submitted your claim form, a single claim form by email, okay, and you wish to withdraw that claim form, you have to do it in the same manner. You will attach a PDF of email of the date the claim was sent, a copy of the claim form, a copy of your attorney authorization, and a signed letter from the client authorizing the withdrawal of the claim. Us at Beasley Allen, since we are submitting all of our claims by CSV and batch filing, I will then send an email to clclaims@us.navy.mil with the date that I emailed the claim, the unique batch or ID number, because they do provide that to us, the CSV containing only the claim that I wish to withdraw, not the entire batch, a copy of the claim form, a copy of the attorney authorization, and a signed letter from the client authorizing you to withdraw the claim. So those are very specific steps you have to take if you wish to withdraw the claim. Same goes if you need to amend a claim. You need to amend it, again, the same way that you filed it. So if you are amending by paper, you will submit a new claim form and just indicate to the Department of the Navy that it is an amendment. If you were previously provided a claim number, please reference it in your letter or your email. If you submit it by CSV, the original claim, you will submit a new CSV with the changes, not the entire CSV, but submit that specific claimant's CSV with the change. And if you have a claim number, please reference that as well. All right, so you can go to the next slide, Matt. So of what happens, this is a process recap of what happens after you file your administrative claim. Perfection determination by letter. Typically, you will get a letter 3 to 4 months after you file the administrative claim. Then you're going to get your substantiation request letter, kitchen sink letter, I like to call it. So you get that. And then at the same time that you're putting everything together for the substantiation request, the Department of the Navy is conducting an internal investigation also. And after they determine substantiation is complete, They might say settlement is warranted. All of us on this call, I don't know. I think that's, it could be laughable, but we're going through the process. So if settlement is warranted, there's negotiations, settlement, and you're paid and you're done. But if your claim is ultimately denied, then and you want to have the Department of the Navy reconsider any part of your claim, if it was not perfected or if it was denied, ask for reconsideration. And ultimately, 6 months post-filing of your claimant's administrative claim, you can pursue litigation. As Julie and Matt might have touched on earlier, the Department of the Navy is no longer that claim. If you pursue litigation, is no longer in the Department of Navy's hands. It is transferred to the Department of Justice. So that is what happens after you file the administrative claim. Next slide, Matt, please. I think Julia is going to handle some other useful updates that we found out since we've received perfection and substantiation letters.
Yeah, so these are just a couple of kind of housekeeping updates that we've gotten from JAG. The first is this portal. It would be so nice to have a portal. So they said that they have completed the technology of the portal. It does exist, but they are not ready to launch it yet because they have to protect, they have to find a way to make sure all of the personal information is protected, which makes sense. And they said, if we were a private law firm, this would have already gone live, but we are the government. We have a lot more security measures and other concerns that we have to go through, which makes sense. They are hoping that it goes live by summer. And here are some of the things that we get to look forward to once this portal has gone live. We're going to be able to batch file on there. We're going to be able to link claims together. We're going to be able to see if there are duplicate filings for this potential dual, triple, quadruple rep situation that we're all probably going to be upon soon. And then you'll be able to see the claims you filed and their status. So that's something nice for us all to look forward to in the summer if this actually is able to be rolled out in time, which would be great. We have heard that the Navy is accepting requests for preservation depositions. So if you have that, you should email Jennifer at JAG. If you have a client who is dying and you would like to get a preservation deposition on the record, you can request that. And then I want to talk to you all about this fee cap. So there's a lot of scuttlebutt going on about what's going to happen with the fee cap. As you know, the Federal Tort Claims Act has a 25% fee cap. This is not under the Federal Tort Claims Act, as Matt talked to us about earlier. So a senator from Alaska, Senator Sullivan, last year introduced this bill trying to get he called it the 210 provision, a fee cap for 2% attorney's fees on the administrative claims process and 10% fee cap if you were to go to litigation. Thankfully, that has been stopped in its tracks. I don't think anybody would really want to have an attorney who's only getting 2%. Like, you get what you pay for, right? So that's not a good proposition for anyone, I don't think. The next bill that was introduced was from Senator Durbin of Illinois, and he introduced a 20-33 1/3 provision, 20% attorney fee cap for the administrative claim process, 33 1/3. That went through negotiations for a while and is no longer on the floor. Now there is a third one, and it was most recently introduced, and it is entitled the Protect Camp Lejeune Victims Ensnared by Trial Lawyers Scams Act. So that's a real cute way to spell out vets. So the goal there is for them to impose 12% fee cap for the administrative process and 17% for everything else, including trial. Now, as trial lawyers, we all know how much work goes into trial. And so I would encourage you to keep your fee as what you consider appropriate, and let's let this play out. The American Association of Justice is in the trenches on these issues. They are advocating for us as trial attorneys. I encourage you to join AAJ if you're interested. There is a Camp Lejeune section, and they give us routine updates, but you have to be a member of that group in order to get those updates. So just stay the course, be patient, and continue charging your clients what you believe is appropriate. And I have a feeling there's going to be some sort of an update, but we just have no way of knowing what it is. So, all right, let's go to the next slide. These are just some resources that we wanted to share with you all. Write them down, and they've got some good information that we use as a resource. So we just wanted to share that. And now what is the next slide? Okay, so this is the time that we have dedicated for you to ask us questions. We're going to answer questions live, and David Byrne is going to take over and tell us a little bit about, how to get CLE credit and any other housekeeping matters that we have.
Absolutely. Thank you, Julia. And on behalf of all our viewers, I want to thank our entire panel, Julia, Matt, and Leslie, for bringing us a great presentation. Every time you guys present on this subject, I learned something, and I know our viewers do as well. We have received a number of questions during your talk, and if you guys will allow me, I'd like to present them to you and get your feedback. So our first question comes from Denise. Denise asked, how are you obtaining housing records and proof that a client actually lived at Camp Lejeune?
Leslie, you want to take this one? That's
Sure,
okay.
I can take that. Sorry. So we are obviously ordering any military records. So Denise, I don't know if you're talking about just a civilian or an actual member of the military, but if they're a member of the military, you can order their DD-214 records or their entire military records. You can also, we ask for if there's any kind of old bills, a history report, photos of the home that they lived at, anything that's going to provide evidence that they were there and residing there. Doesn't have to be the actual military record. If there's any other proof that they can get creative with, then that's what I would do. I hope that answers the question.
And Leslie, while we're on that point, that ties into a question from Greg. And Greg says he's got a claimant that's deceased. How does he go about getting the DD-214 and military records for that client?
Yeah, so on that resource tab, the PDF, the slide back, Matt, I don't know if you're able to go backwards one, but I think you should have the materials. You can get the military records there. It walks you through the entire step. So if they are deceased and there's an executor and authorized agent, they will be able to get those records.
All right. Stephen asked, is a client required to file suit if 6 months pass with no action, or like with the FTCA, is filing discretionary at that point?
I can handle this one. It's completely discretionary. So you have, and Matt, I might need your backup on this, but you have 6 months after the end of the Camp Lejeune Justice Act period. So the act was passed August 10, 2022. You have 2 years to file the administrative claim. So that is August 10, 2024. And then you have 6 months after that to file your lawsuit. You do not have to file a lawsuit. You can continue working with the Department of the Navy and JAG to work on substantiation and to work on trying to get some sort of settlement. Now, if, proceed at your peril. Either way, there are difficulties with going either route. So, and we're just getting there because it's February. We're just at the first 6 month period after the initial claims were filed. So that we're right in that process right now.
Okay, our next question comes in from Vanessa. Vanessa asks, when evaluating who the proper party is to bring the claim, are you looking to the state law where the decedent resided at the time of death, or are you relying on North Carolina law and therefore believe that all cases involving deceased clients will require an estate?
I can handle this one. You can do either. Again, I would retain a great estate attorney, or if you have a great estate attorney on staff, rely on them, because this act is unprecedented. There has never been anything quite like this. So, you can work with estate attorneys across the country. You can work with a North Carolina attorney to determine what their estate processes are. But I would just encourage you to, do your due diligence.
I would also like to add to that, if you don't mind. I'm going to read exactly some language from an email from the Department of the Navy with regards to this issue. So the FTCA damages follows state law. North Carolina only allows individuals who would receive proceeds pursuant to the intestate succession laws to receive proceeds of a wrongful death action. Proceeds do not pass through the decedent's estate. If a claimant would not be able to recover damages under state law, they would not be a proper party to file a claim. So please take note of this legal issue.
That's excellent. That's excellent. Thank you, Julia. Thank you, Leslie. So two-part question coming up. The first part of this question comes from Beth. She asks, are you filing a separate claim form for loss of consortium claims? And then David asks, for a living client who is married, are you filing a separate loss of consortium claim document for the spouse? You guys need
Julie
to
and I, sure, Julie and I can both take this one on. It's been an internal discussion amongst us as a team right now at Beasley Allen. And I think what we're intending on handling loss of consortium claims on an individual basis. We're going to look at the facts and the actual injury before we file one. And as I stated in my part of the presentation, the loss of consortium claim has to be a separate claim. If you file your claim form with the LOC claim and the claimant's form, it'll come back as unperfected per the Department of the Navy. So it has to be a separate claim. And the other, on the claim form, you will check off other as the basis of the claim and type in loss of consortium. You have to be very clear about that.
And I'd like to just add to this that since no claims have been paid out yet, we don't really know how this is going to play out. If you look at the statute states that, you have to have been at Camp Lejeune for 30 days and have one of the requisite illnesses. So a loss of consortium claim is a completely different animal, and the person who is filing it has not been on the base for 30 days, more than likely. So that's part of the discussion Leslie and I were talking, Leslie was talking about. If you file a loss of consortium claim, yes, it has to be a completely different claim form. Jennifer did state that that in order you can file a loss of consortium claim, but she references the Federal Tort Claims Act. As we've stated, these are not under the Federal Tort Claims Act. So we're just going to have to let it play out. But I wouldn't want to waive those claims if they are viable.
Good answer. Thank you so much. So next, we have a logistical question from David, one of our viewers. He asks, for some clients, particularly ones who died years ago, their old medical records just no longer exist. So what is Beasley Allen doing to establish diagnosis if the providers have destroyed old medical records or claim to no longer have them?
Sure, I would go back and I would try to get any kind of Medicaid, Medicare, their VA records, insurance records, any kind of billing records, anything that might indicate an ICD code, an ICD-10 code per any of those other records, if the actual medical records were destroyed.
And just to add to that, another great source is the death certificate. So Beasley Allen, what we're doing for our wrongful death cases, we're evaluating the death certificate and we're seeing if that lists one of the presumptive injuries or one of the known associated injuries. If it does, that provides all the documentation that you need. Where you run into the problem is if the individual died of an unrelated cause and on the death certificate it's not listed as a underlying cause, and at that point you're kind of at the mercy of what kind of records you can get to substantiate that claim, because that claim will then shift from a wrongful death claim to a personal injury claim. And so like Leslie said, it's you're going to have to get creative at that point to document that there was a diagnosed injury associated with water exposure to Camp Lejeune.
Right. Thank you, Matt. Thank you, Leslie. So our next question comes in from Stephen. Stephen asks, I submitted a CLJA claim on November 1st, 2022, but haven't received a letter of perfection yet. Is that something I need to be concerned about? What do you guys think?
No, they're coming. Stephen, it's coming.
Yeah.
They're doing them in batches. August to October was given priority, and then our next batch will be, it's coming. We've been told they're coming. So be patient.
All right. Fantastic. We're coming up with just a few more questions, if you guys can bear with me. So our caller Scott asks, what would be considered legal name of a woman who was unmarried at the time of service, but has since been married? What would be considered the legal name of a woman who was unmarried at the time of the soldier's service, but has since been married? Or at the time of their service, excuse me.
I would say the current. I would say the current legal name.
Yeah, and the name is being asked to be referenced with the social security number, because in the event that there is any settlement offered by the Department of the Navy, there will verify social security number with legal name and tax identification number to make sure that the money is going to who's being stated on the form.
Yeah, it kind of makes sense too, in terms, if there is a settlement offer, that she would have to be able to cash the check in her current legal name. So that's the way I would go with it.
All right, we've got time for two more questions. If you guys don't mind, you're doing great, and I know we're throwing a lot at you, but this second to last question comes from Marcella. Marcella asked, how are you able to batch file, and how could we do that?
There is a batch filing procedure on the Department of Navy website. And if you want to email any of us on our team, we can help you show you you have to register as an attorney. You have to then do the batch filing registration form. So if you send any of us on this team an email, we can help you walk through that.
And Julia, you make a great point. Any of our viewers who want to reach out to panel members, you can do it by email, or you can do it by dialing 1-800-898-2034. 800-898-2034. These guys will be happy to help you. So our final question for the day comes in from Greg. Greg asks, how do they define accrual? I have a case where the veteran was diagnosed long before August 10, 2022, but died after August 10, 2022. Is the wrongful death claim barred because it didn't accrue before August 10, 2022?
No. So
No.
yeah, if I'm understanding the question correctly, if the decedent passed before the act was passed, August 10th, 2022, that is still a viable claim. The only point that if there's any injury that's been diagnosed, whether it's personal injury or wrongful death, up to this point, it'll be a valid claim given it meets the other criteria. Now, the only issue we'd run into, some firms are taking medical monitoring cases for this litigation, an individual that was there, but has not experienced any injuries up to date. And that's the only time that a timing of an injury would be an issue, is if that injury occurred after that August 10th, 2024 period. But in that event, if the individual had filed a claim and marks no injury, I would assume they would be able to update it and say that there was an injury, but that's kind of speculation on my part.
That's right. And if
Right.
any of your claimants filed personal injury claims during this process and now have passed, that's where I talked to you about amending your claim. Now bring your wrongful death claim. So you amend from personal injury to wrongful death now.
All right, very good. So before we wrap up today's webinar, I do need to go over a few CLE housekeeping notes. So today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you're going to receive another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars beasleyallen.com. For those Alabama and Georgia attorneys participating today by phone, please email us your name, your phone number, and your state bar ID number. Send that in to us at webinars@beasleyallen.com. That way we can ensure you receive full CLE credit. And for those of you practicing in other states besides Alabama and Georgia, we're going to send you a certificate of attendance that you can present to your own state bar to try to obtain credit on your own. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout 2023. In fact, if you simply tune into our webinars each month, you'll get a full 12 credit set for the year. You literally can complete all of your CLE credit for the year just by tuning into these websites. So thanks for joining us today. Thanks, panel. And thanks to all of you for supporting our Beasley Allen webinar series. Have a wonderful day. Thank you.